John GITHONGO, a lawyer and a member of Raila Odinga's campaign secretariat, a constitutional lawyer and a law publisher in The Elephant, have penned down a very interesting article on the BBI. The Building Bridges initiative was stopped last year when in Parliament, and the ruling that was made by the High Court was upheld by the Court of Appeal. Then the BBI promoters moved to the Supreme Court, and then tomorrow, the 31st of March, the Supreme Court is supposed to give a verdict on that appeal. So when BBI was stopped, it was at the National Assembly. In this video, I went through that article, and what GITHONGO is simply saying are the three unlikely scenarios. If you read that article, the interpretation is the three likely scenarios that will play out after that Supreme Court verdict. I want us to look at those three scenarios, but to make us better understand the context of those scenarios, I want us to little bit go back a bit and look at the journey of the BBI until it was stopped at the National Assembly. And I'll try to be very brief, so I'll be jumping bit a bit. The ninth handshake, after the handshake, they made Uhuru Kenyatta and Raila made committee, the steering committee, and it was launched on 24th May the same year, 2018. And that committee was supposed to, it had terms of reference. So the terms of reference was to evaluate some 9 points agenda that both Raila and Uhuru had identified as the things that would be bedeviling the country. So this team was to evaluate this. Then after evaluation, do some public participation, then come out with policy, administrative, and reform proposals just from the report. Then after that, the term was renewed. When it was reviewed, it was now made to be a task force. So from the task force, they now gave the proposals. And of the policy, administrative, and reform proposal, there was one proposal. There's some proposals there that needed the constitutional making, constitutional review. And these three were touching on the reorganization of the executive. That's why the post of prime minister and the rest were there, the deputy prime ministers. The other one's touching on devolution. Remember the 1 shilling, 1 man vote narrative then. The other one was also touching on the National Assembly, composition of the National Assembly, and so on. So that is why it needed that process. But again, the constitutional making process, if you look at that process, it was a popular initiative. There are only two initiatives. There is the one initiative, the parliamentary way, just the same way it may be something, an idea or a review comes from the executive, it goes to Attorney General, then it's taken to the National Assembly through maybe the leader of majority or a member who is, or any other member. Then it goes through the 3 stages of reading. Through that, President assigns and becomes a law. But unlike that, and I think the parliamentary way is the shortest way, but the most effective way to even allow public participation is the popular way, is the popular initiative. So the popular initiative is the one that after the proposal, that is why it was submitted to both Raila and Uhuru, and they collected the signatures. It went to IBC. After going to IBC, then the county assembly. After the county assembly, then it was to go to the National Assembly. Actually, it was at the National Assembly. If I'm not wrong, I think even the National Assembly had passed it. So it was at the Senate. Then through that, it will be processed by IBC. Actually, from the review, from the task force, it was to go to IBC, then IBC processes. process the other bit. It will be formulated into a draft, then subjected to a referendum. So all was set until that was stopped. It was stopped on very many grounds. There actually, if you look at, if you read the grounds that the High Court stopped the BBI, actually, I think in entirety, there was a problem. Let me just name bit of bit. One, the composition of the task force. They were saying that unlike it's only the president and his deputy, the personal staff of president and his deputy that can be appointed directly. The rest must go through a merit-based process. So even the composition of the task force, the way it was elected, the way they were appointed, it was appointed on some sycophancy. So even that was termed unconstitutional. The other one was also on the popular initiative cannot be initiated by the president or the government. It is the way that is left for the common man, because when it is done by the president, it can be misused. That is someone say, they say president do not have that role. But again, the president was saying, I was starting the BBI in the spirit of bringing the unity, which is one of the roles of the president, So all this was there. There's one that was also very interesting, is on voter verification, on signature verification by IBC. So they're actually saying that the constitution do not give a legal framework for even the IBC to verify the signatures. Then it takes me back to this popular initiative was once done by Raila. If you remember the Okoa Kenya. So the Okoa Kenya was a popular initiative, and IBC rejected the signatures on the grounds that walikuwa wamechora ng'ombe and some animals there. So if you remember, this has been back and forth, and very other interesting bits where the court poked holes on the process here and there. Even the framework by the National Assembly. There was one that was saying that IBC was supposed to publish the names and the signatures of the people there for 2 weeks in the portal and receive complaints. So how was IBC going to publish 1 million names? That is also there. But the IBC published them for 4 days instead of the 2 weeks. And this and that has been there. So I was just naming that. I was also touching into something. One of the things that the president was facing there, the biggest challenge the president was facing, was being told that some of the proposals that were given by that task force, that were made by that task force, were usurping the powers of some institutions in the country, like the NCAC, powers of the IBC and the EACC. We are going to look at all this. So ladies and gentlemen, I want us to pursue the 3 likely scenarios that will play out and see their implications moving forward. Kindly subscribe. And also give us your feedback. If you are also a lawyer, what are your projections? Murkomen is saying that pro-BBI supporters or pro-BBI team are celebrating before the Supreme Court verdict. I don't know why. But in this video, I want us to look at the 3 likely scenarios. Now, one, according to GITHONGO, is this, that the Supreme Court might reject the appeal. Let's say they might uphold the appeal in eternity. What this means is, if the people, what they presented in Supreme Court is, if that appeal is upheld, then what that means is that BBI will continue from where it was. So because it was at the Senate, it was heading to the Senate, it will head to the Senate, then pass, then come back to IBC, and all this is here, IBC to draft it, and maybe we can have a referendum alongside, we don't know, somewhere, maybe in the general election if the law allows, or somewhere. Someone can tell us whether it's allowed for the referendum to be held alongside the general election. This is something that I think the William Ruto team were proposing, that instead of having a referendum, let's just merge them with the general election. So in that likely event, there are many things that are also to fall into play. But this is so unlikely because one of the roles of the judiciary, I think we were first treated to the fact that judiciary was just doing some activism. But one of the roles of judiciary is to protect the constitution. Now, if you look at the way the grounds on how BBI was stopped, there is bit of that constitutional torture. Somehow constitution is being mutilated. So I don't see entirely the BBI appeal being upheld. This is also in the public space. You know, the BBI was a very contentious issue because it formed the basis of a political narrative in this country between the Raila Odinga team and William Ruto team. So in any case, the court are going to side with the president and Raila. They might be seen as they were compromised. That could be because, you know, the two courts, this appeal have gone, High Court and Supreme Court were the same side. So if High Court and the Court of Appeal, if Supreme Court gonna side the other side, in the public, it might also dent the image of the judiciary. So the issue of it entirely might not be there. It also has budget implications. If BBI is to go through and the general election, imagine having a general election in BBI the same year. If it also has some budget implications, and it might bring the narrative. Remember, the Azimio concept came after the end of BBI, so I think it is going to be a mix-up of all. Now, two is partially some parts are allowed, are termed constitutional, and some parts are termed unconstitutional. Now, that is what is going to happen. Take that to the bank. That is, there are some that they are going to win. They are going to win some small battles, some small clauses here and there. There is one that was saying whether the president will be charged for flouting the constitution after this. Those are the ones that maybe are not. Because one thing you need to know is this verdict, the Supreme Court verdict, is going to set a precedence. It's going to set a precedence. That is the point. So, in the event that happens, the only question is the policy, administrative, the ones that reforms that needed the constitutional review process might be, they can see. But what will the policy and administrative maybe can still the light of the day, and they will be adopted. What will be done is, what Supreme Court will uphold, the Raila Odinga team will run with it. They will actually go with it in the manifestos and as they move towards 2022. That is the most likelihood. Now, three, if the Supreme Court upholds the verdict by the Court of Appeal that the BBI is dead, that will be the last nail on BBI. Now, let me tell you what that means. One, the BBI conversation will come to an end. And if anyone, or maybe if Raila forms government or Ruto forms government, I think Ruto is not pro BBI, so let's use it through the Raila way. Let's talk about it through the Raila way. If the Azimio fellas form government, then they want to even change the constitution, it will not take a popular initiative from Raila's side. If it has to be initiated, then it will be initiated by a mwananchi, maybe a civil society somewhere, maybe a Kenyan somewhere, but then use the Supreme Court verdict as a precedence. That is very unlikely. That is the challenge, because if Raila forms government and he wants to move on with the BBI, we've always been told that BBI is at halftime. So if it's move on, some of these fellas around Azimio, like Kalonzo and the fellas, they want posts, and some of these posts depend on the fate of building bridges. If Raila Odinga is going to implement some sections of it, or is going to revive it, even the Deputy Prime Minister's post and all that, they depend on BBI, and that is most likely in 2025. So these are the three scenarios. And what do you expect from your end? I don't think they're going to just tumble everything down. There are some battles, small, that some few sections that these fellas are going to win, especially even on the verification of the signature. The framework is not, it's not by law. So the lacuna is not just at IBC, but even the parliament had not enacted such a law. I've spoken a lot of law, and I'm just a communication person. Yes, and I don't want to end it there. Let's wait and see what The courts are going to say tomorrow.